Hey, everybody. I'm back. At least I looked for my news, right? I missed you guys last week. I'm sorry. But I was on vacation, and everybody gets a vacation. I don't care what time of the year it is. So it was great. I went to see my grandkids, in case somebody was wondering. I mean, it's a grandkid vacation. But I'm Chuck Cook, Greg Sinsky, Aaron Hall, Jeff Joseph, all these guys working on your behalf. So I want to jump right in to the discussion on the Gomez Aker case. And the reason I want to jump right into this is I just got off a phone call with government lawyers. If you're a Gomez Aker plaintiff, you know that part of the judge's order was for the parties to work out a date by which these visas must be issued. And if you recall, during oral argument, the government suggested sometime in fiscal year 2023, which is sometime in the next 2 years. So not like October 1, 2023. You can guarantee it'll be near the end. So more than 2 years away. And of course, the judge clearly dismissed that as an option by telling the parties to come to some agreement, because if he thought the government's request was legitimate, he would have just ordered it. Right? I mean, to me, that's what happened. Well, the government doesn't think that. And so the government's position is that all the visas, they get to wait until 2023 to issue them. Really, that's the government's position. And it's because they're busy. They're just really busy. They got lots of stuff to do, things to do, places to go, people to see. Can't get to it. Can't in any way figure out any way to adjudicate 9,000 visas before September 2023. It's just impossible. Can't do it. COVID, Afghanistan, limited workforce. That's it. And that's all we talked about. It was an entertaining 30 minutes. That's all I can tell you. We will be filing on Wednesday, a joint notice to the court about our discussion. Now, I will also tell you that we asked the government a series of questions. I'm going to tell you right now. These are the questions that we asked the government to answer after the order. And these are legitimate questions, and I'm going to tell you. Here, the first question is this. Can you identify for us the DV 2020 selectees who are part of the Gomez class eligible for the 9,095 visas, broken down by country of residence, geographic region, etc.? Who is going to get these? 2, will the KCC repost or identify the number of entrants from each DV processing area who were selected? Will they maintain rank order of these visas? Will they schedule appointments for documented qualified applicants, not only within regional rank, but make sure that no one region is over-allocated? We also asked them, will their randomized process, remember the judge used the word random, nevertheless prioritize individuals who had appointments set but were canceled because of COVID closures? Will they reopen and re-interview people who, this is my questions, who were denied solely because of the Muslim ban? Will they include individuals who were interviewed but whose cases were denied due to the expiration of the fiscal year because they were in administrative processing? Does the Department of State agree that the court's order stating that all individuals with expired DV 2020 visas can enter the U.S. regardless of expiration date? And then finally, will the Department of State be willing to transfer interview applicants away from the current books that are closed due to COVID or other country-specific circumstances like Afghanistan? Guys, these are good questions, right? I got to know the answer to these questions. The government's answer to these questions is, we're not going to answer these questions. There you go. So when you ask us these questions today, and I'm sure you're going to ask us these questions, they're legitimate questions. Government won't tell us the answer.
So what is the status report going to look like?
The government's going to have a part of it. The government's responsible for the report. They're going to say this. We can do these cases in 2023. That's it. They're not even going to explain why. 2023. Our part of the report will say, Judge, we understand your order to be explicitly rejecting the 2023 date. we recommend that all of these visas be processed within 6 months of the court's order. So let's say by February of 2022. That's literally $1,500 a month. I mean, it's not around the world. I mean, some countries that means one. I mean, it would be one. Okay, one per month. I mean, it wouldn't be very much. Because again, they have to go by I'm going to assume, and I think this is a legitimate assumption, that they will look at the cases approved. They will make sure each country gets a balanced number according to the numbers selected in the overall lottery. I think. I mean, that's what I think they should do. Besides getting our clients scheduled that were already, missed their deadline. But I don't know. So we're going to say that, and we're going to tell the judge, by the way, we asked them these questions to help us understand how they will implement your order. And by the way, they didn't answer them. They refused to answer them. So, judge, do what you're going to do. I mean, the key question to me of all these questions, I think the most important question is, can the people who have DV 2020 visas, but which were expired during COVID and who could not get reissued, can they come in now? Because your order says they can. It says they can't. So which one's correct? That's the one we need answered. And that, as you know, was our class action request. He dismissed our class action saying, well, the government's going to let him in. And I don't think he understands what they did. So, guys, any questions for me about Gomez and Aker? You look like, oh my God.
I mean, you might want to talk about how the questions are going to be how it implicates Go. So we might as well talk about that.
Let's talk about Go. So, Jeff, now that you know all this, what's your take? I mean, you know what we argue. They heard it all. You've seen it all. Aaron wrote it all. I mean, what do you think?
I'll let Aaron go. He's
Well, these are the exact questions that we're getting from Go plaintiffs on a daily basis by email. And our response to all of you, and sorry if you're frustrated by it, but it's typically, we don't know, and we won't know until after we get an order from the judge. Because after we get an order from the judge, the process is very likely to look similar to what Chuck was just describing now. A phone call and a report following the order, assuming a positive order, regarding the implementation of the order. And these are the kind of issues that have to be hammered out afterwards. Now, in my opinion, I don't think Judge Mehta is going to be too happy with the government refusing to engage on these important questions. And so I think that this is all going to get hammered out, and the process will look similar after we get a decision in Go, hopefully a positive one. But beyond that, I think we're still waiting for the order. And, the fact that Judge Mehta made the Gomez decision last week makes me think he's basically considered the issues. I'm sure he has to consider something specific to our case, but I would, who knows when the decision's going to come. I'm hopeful that it might be this week.
He may be waiting for this status report from the parties, thinking, he's probably thinking, I'm sure they'll come to a date. It won't be a problem. Surely the government will not stick with their 2023 date before he issues Go, so he knows what to order. And I obviously he's very considerate. He's, what can the government do? But the government position is we can't do anything. The interesting part of the conversation today was they never brought up the fact that they're supposedly hiring hundreds of consular officers. I mean, you're not going to have anybody, you literally can't do anything. And the funny part is they said we can't possibly prioritize these visas over other visas. But that's exactly what they're doing. I mean, they're already prioritizing visas over everything else. They issued 7,000 visas last September in 3 weeks. Clearly, and the prioritization program is clearly illegal. Anyway, so I mean, for the Go folks, yes, it's sitting on pins and needles. The timer's running. We've had a number of our Go plaintiffs get interviewed. A couple today send us notices that they've been approved. I think we have several in Afghanistan that are in Go that are waiting. Why aren't they issuing those? What are they doing there? Supposedly sending consular officers from around the world to Afghanistan. I mean, I think maybe they never heard of Zoom. I just don't get this fact that this is not an emergency per Greg. How is this not an emergency?
Well, and them saying that they can't issue these before fiscal year 2023 because of, they're saying it's largely because of COVID. You just lost on that argument. You lost. The judge said you could do it, and it's the same arguments in Go, and so I just can't see how that can be an acceptable answer. You can issue them. You're issuing other kinds of visas.
Any indication that they're going to take an appeal?
They actually were asked that question specifically and said they had not yet asked the Solicitor General because they don't have a final order.
Okay.
That's how they put it. We don't have a final order, so we don't know if we're going to appeal. I don't know. I mean, do they really want binding case law from a circuit against them? Are they willing to roll the dice on this one? Because I don't see the Supreme Court taking this case. I mean, with no split the circuits, and so I mean, do they really want to go to the DC Circuit Court with what's already on display there with Al-Makrami? So I don't think they're going to appeal. I think they're just going to go ahead and do what the judge tells them to do. But I don't, who knows at that point. But I don't think the judge is going to give him a stay. Maybe the Court of Appeals will, but I don't think Judge Maida is going to give him a stay. So there you go. That's our Gomez Aker Go update as part of this. So let's look at some of this other stuff. Jeff, how's Milligan going?
Yeah, let me give you a few updates on Milligan. The first is that we got an order from Judge Boasberg today ordering the government and us to submit a joint status report by Friday, so within the week, letting the judge know which plaintiffs remain in the case, and I believe why I think the order was which plaintiffs remain and why they remain in the case. So
obviously not a question to us, right?
Yeah, so I think that's a sign that he's going to rule very soon, and that he's really, the fact that he's asking about particular plaintiffs indicates to me that he's prepared to rule on the mandamus, and he's considering the delays in individual cases. So that's good news. The second update in Milligan is that I did email Joe, and we got together and we looked at the stats from round 1 and round 2 of Manila, and also from Ramirez, the companion case that we filed specifically in Manila. And here's what we found, is that if you go by what the government says is documentarily, they don't use the word qualified, they use documentarily collected or something, then it's pretty much, with a few exceptions, first in, first out, right? The question is, we don't know what that documentarily complete means for purposes of the government. So I have asked Joe to explain that, to explain what the government considers to be documentarily complete, because if you go by that, then yes, the government is pretty much, with a few exceptions, first in, first out for both Ramirez and for Milligan. So as soon as we have that information, we will, we'll get back to you and let you know what they say. In the meantime, because we have this status report due on the 27th, it is really super, super, super important that all of you who are remaining update your case status sheets. And Greg will send out, or somebody from his team will send something out.
I think it went out because I'm getting a bunch of people responding in the last 20 minutes.
Awesome. So that's what we're going to use to report back. The government said that they're going to start the chart from their records, and then we can comment on it as we need be. So, so great news in Milligan that it seems like that case is progressing.
I think that's really great news from Judge Boasberg. I had Judge Boasberg on another case recently, and we were able to come to an agreement when the government lawyer saw that Judge Boasberg was assigned, and the government quickly adjudicated what I was asking for, and we dismissed the case. So I think the government clearly sees the writing on the wall here. He would not be asking for the status report if he was just going to deny something. We just wouldn't do it. So that's a great, great sign. So let's talk about some of the other K1 cases here. We've got the Rio case. Any update on that? I mean, I know it's just still kind of pending there.
No real update on that one. It's fully briefed, as you know. All the case is in, and we're just kind of waiting at this point. So nothing to update you on there.
And we've also got our K1 London case. I believe that's coming up on the government response date, if I'm not mistaken. I'm pretty sure that's the case. It's coming up pretty quickly. In fact, let's take a quick look at that. That's the. I'm going to just take. I've got my database up here, and I'm going to look at this real quick. If you guys would bear with me as I efficiently use Pacer to get that information up here. That's the King case. So take a look at King here, and we've got. Let's see, the government. Oh, Joe Carilli has entered his appearance in that case. So Joe Carilli is the lawyer in the King case as well. And looks like we still got another. It looked summons issued, return of service. Looks like about another 14 days, 20 days, something like that, for the return of service. Service on 7/8. So we've got about 14, 16 days for the government answer. So we'll keep you updated on that. On the Moscow case, this is the Ponomarenko case. I'll give you an update on that. I don't have Waleed with us today. But on the Ponomarenko case, we're
just waiting on the judge to rule on the motion to dismiss.
That's right. We've got that pending. It's all been pending since last week, and also a Joe Carilli case. So hopefully we'll get that decision relatively soon on that matter. That's actually Judge Mehta on that case. So, one of the things that people ask a lot, guys, is why is the judge taking so long? Jeff, why is the judge taking so long? On any case.
On any case? Well, I mean, we're only one of their cases. They have probably hundreds of civil cases and hundreds of criminal cases that they're trying to resolve all simultaneously. So we're not the only show in town, and they've got plenty of other work that they're responding to. So, I know it seems like a long time for you because you all are, waiting and for your visas and separated from your family. But for us who do this all the time, this is not unusual in any way.
And actually, this is still faster than just letting immigration do their job or U.S. Department do their job. Just litigated like this. Jeff, Kinsley, we're still waiting on Kinsley, aren't we?
We are waiting on Kinsley. Just waiting for a decision on that one. That one is also fully briefed through summary judgment. So just waiting for a decision.
Now, we've had that pending. Let's see. I'm going to take a look at the docket report in Kinsley. We've had that pending with the judge on full briefing since the middle of July. So, and the government has their joint appendix in. So hopefully soon on that. The thing about Kinsley that's so important, Jeff, do you want to talk about why is Kinsley so important?
Well, because Kinsley is a straight-on challenge to the proclamation itself, right? So with regard to, not the proclamation itself, but the use of the proclamation to ban visa issuance. So it's really important because it's the big ban. We've challenged it across categories, across non-immigrant and immigrant categories. And it's really sort of our broadest challenge to the application of the proclamations overall.
And if we are successful in this does away with the whole NIE thing, doesn't it?
It would.
NIE's gone. This national.
Well, not completely. I mean, you still need an NIE to come in before 14 days.
Yeah. Okay. But it does. But the Department of State is using the NIE to not issue visas.
Right. No, that's right. I mean, it definitely will make the NIE a lot less important because people can just park somewhere for 14 days and come in without an NIE.
So that's why Kinsley is so important, because it forces them to issue the visas without regard to whether or not you qualify for an NIE, which of course is just a made up thing for them to get around the 14 days. But if that happens, that should free up a lot of consular time. It's a lot of people won't ask for an NIE if they can just park somewhere else and get their visa anyway. I mean, a lot of people would go somewhere else rather than wait. All right, so that's our Kinsley case. I want to briefly update you on the H-1B lottery abuse case. As you all know, the hearing was postponed, and we're going to be going to summary judgment in this case. We're finalizing the request for the administrative record. We'll be asking for how many people filed. I mean, how many people filed duplicate applications? How many companies filed applications for people that were duplicated? We're going to be asking for a lot of information. hopefully get in about 3 weeks, and then towards the end of September, we'll be filing our motions for summary judgment, and likely be fully briefed by the end of October. We believe that there is a small possibility that there will be an additional lottery. And I think a lot of our clients believe statistically there will be an additional lottery, but we're going to get a lot more ability to estimate that once we see the numbers.
Grant, Chuck, I think there's some feedback on your phone. It's kind of reverberating. I don't know if other people can hear it.
I don't know why that would be the case. Let me see what's going on here. Talk amongst yourselves. Let me see if I can figure this out.
You want to skip to the other H-1B case, or we can talk about that. Okay. All right. Well, we started to get some data as far as some plaintiffs are actually getting adjudicated. Some of them are getting biometrics. So that's all good. It does look like USCIS has in fact taken some of the information that we gave them and is moving it along. But we filed, I guess, since our last call, we filed the injunction motion.
That's right, and that's not my feedback, by the way, because that feedback kept coming when I went to mute. But we did file that with the government. We have, I think our brief's very good. I think we've got some great reasons. And just today, our friend David Beer from Cato tweeted out a very interesting analysis of USCIS's issuance of EB adjustment of status cases. And what's fascinating about that, and Greg retweeted this as well, is they said that in the last quarter, because these were third quarter numbers, they'd only done 29,000. And if you add up the 3 quarters together, you only get the 79,000. And yet in their year to date, they said they had done 107,000. They double counted the third quarter in their year to date numbers. So there is zero chance they will even use the 140,000, let alone touch the 120,000 that are sitting there in the flow over from family for last year. So great factual information, which we'll include in our reply. Now, our legal theories good? I think we have good legal theories on this. And I think Judge Maida's decision is extraordinarily powerful. Obviously not controlling, but extraordinarily powerful, that when the government doesn't do their job, when the government doesn't carry out its essential function, there has to be a remedy for that. And the only sensible remedy is an equitable remedy to reserve the visas. I mean, I think Jeff, you had a big hand in getting that done. What do you think?
I mean, I think you're right that Gomez gives us a lot of ammunition for that argument. Believe me, this is a very novel case altogether to take on, the way that they count visas. I think we're going to have a statutory argument about the interpretation of the statute. I think that's really where the litigation is going to happen is this something that Congress really required the agency to do when they set out this formula for counting numbers? Was it discretionary? Was it optional? Or was it kind of something that Congress wanted as a mandate? And I think that's really where the debate's going to come.
I actually had a conversation once with government counsel who said, in the context of an H-1Bs, we don't have to issue all 65,000. Then why did Congress set that limit? I mean, it's, you really think that Congress said, yeah, we know you have lots of extra petitions pending, but you don't get to them, it's no big deal. No big deal. Whatever. That's a strange way to read that statute.
Yeah.
That's a strange way to read it. Greg, what's your input on that?
No, I think that, first of all, I think the fact that they are interpreting very similar language in 2 completely different ways is going to strike the judge as wrong. I don't think anybody has made the argument before, but that doesn't make it not a compelling argument. I think that it's just the first time that anybody has made it. So I am optimistic that that we're going to get a judge who's going to hopefully at least consider it. What I'm curious about, and I'd like to kind of get your read on it, is, if the judge does something similar to what we saw in Gomez, which is he orders the numbers reserved, but we don't actually get an order to adjudicate the cases until later on when a final order comes down. What does that do for next year's visa bulletin as far as advancing numbers and all that, if there's sort of this limbo without knowing what's going to happen with all these reserved numbers? And I'm curious about whether you guys think that that's going to have repercussions, if we don't get an answer.
Well, think about this. This is why I didn't understand the comments from Charlie Oppenheim about the October visa bulletin, which will come out in a few weeks, that he doesn't think the numbers will move. And yet an additional 280, 250 numbers will be dumped into this pool. And maybe he's thinking, well, immigration is going to waste these, and so they'll just have to use them again next year. But how does that not move the date? It doesn't make any numerical sense that it doesn't, unless, and by the way, when did the visa bulletin come out? Oh, it didn't come out on the 10th. And what do we not know for a fact, but suspect that when visa bulletins are delayed beyond their normal issuance date, that there's politics involved rather than just pure numbers. Because Charlie's efficient. Nobody's more efficient than Charlie at his job. So he's waiting a few extra weeks or an extra week to send something out. That's very suspicious to me. But I think, this is being, for the Biden administration, this is solid gold. I think they have, we got sued on this. You know what, Judge? We agree with their interpretation of this rule. Issue an order. That's all they got to do, right? Issue an order. We agree. Case is over. All right. One last thing, Greg. You want to talk about the wage rule? This is the Humane Society case.
Yeah. So we are getting ready to file. Are we going for a summary judgment or a preliminary or an injunction in that?
We've prepared an injunction. We're talking to the government right now about potentially converting that to a motion for summary judgment with an expedited briefing schedule and waiving discovery.
Right. So that one's almost ready to file that next stage, and we are just basically cleaning up some of the declarations and doing a few other last minute details on that. But that's what's going to be happening next in that. And hopefully, I think we have a pretty, regardless of all the merits of the case, we kind of have that ace in the hole with the illegal appointment of the DHS secretary, which has won in every court that has considered the issue. So we have to do our work to make sure that we're making good arguments on that. But I don't know how the government is going to get the court to reverse what they've been saying pretty consistently in case after case.
The government's still defending that nomination in the California case. This is a unique opportunity for them to make the government run correctly, and they're still defending. This is what confuses me about the Biden administration. They could make long-lasting change arguments, but instead they just circle the wagon. This time
they defend every Trump policy until they get around to coming up with a replacement policy. When they're in court, they act like this is, they defend it all on there. And then, it's all about executive authority. They did that today with there was an article today in The Hill about military naturalizations on that, a very terrible Trump policy on that the Biden administration is still defending. And they do that case after case after case, issue after issue after issue. They're defending the Trump policies until they get around to replacing them on their own.
I just don't get it. There's such an easy way to fix this, and that's let the court issue orders. Period. End of story. By the way, Jeff, you noted that there was a bad sign from the Supreme Court today in a case they took. Tell us a little bit about that case. I think it's fascinating kind of thing.
Yeah, so the case has to do with a nationwide injunction. Remember, we talked, I think, on the last live call about, our strategy for not filing these cases as class actions. because the courts, when they're granting injunctions, hate the idea of granting nationwide injunctions. And especially the Supreme Court hates the idea of a nationwide injunction where you can order the government to just stop doing what they're doing nationwide. So there was a bond case, and I don't actually know the details of the bond case, but it was a detention related issue. And the court in that case issued a nationwide injunction on the detention issue. And that issue is now percolated up to the Supreme Court, and the Supreme Court is going to take on the issue of whether or not mandatory nationwide injunctions in the detention context violate Section 1252F of the statute. And 1252F of the statute is a provision of law that deals with judicial review. And it basically says you cannot get judicial review over certain actions of the government. And they're essentially arguing that detention is one of those sort of broad-based policy issues that you can't overrule from the means of the government. So the issue is going to be ultimately is, does the INA, which was written by Congress, did Congress intend for the agency to be sheltered from judicial review with regard to detention decisions?
Except that the Supreme Court was exempted from the nationwide injunction. And this really, the statute itself goes from removal, inspection, detention. That's what it kind of covers. Not really any stuff we have here, but it's a sign. I mean, frankly, I think the Supreme Court's going to rule in favor of the people appealing, because honestly, the Supreme Court is, what does the statute say? The statute says you have no nationwide injunction. That's what it says. I think Gorsuch is going to say, dude, the statute says what it says. We have no jurisdiction. So anyway, fun stuff. Let's answer some of the questions today. This is what we get all the time. We've gotten thousands of emails, it seems like. Will the judge give priority to Go plaintiffs to get interviews before the end of the fiscal year, or just reservation? The answer is we don't know what the judge is going to do. We have asked for plaintiffs to be given priority. We've asked for cases to be reviewed at the end of the year. But that's why we ask for reservation, because we don't know if it will happen. And I want to thank the plaintiffs that are emailing us every day. They just got their DQ. They just got their appointment. They just got their visa. Thank you. Thank you for letting us know them. Send us a picture when you come to America. By the way, if you do get a visa, get your bum on an airplane and get here and use that visa. Who knows when Biden's going to close America again? I mean, I'm just saying, right? Are we planning to use recent released Q3 numbers? Yes, I already talked about that. Look at the dude's name. Death metal poet. Really? Rock on, dude.
I think I did the I love you sign, not the rock on. Let's do that again. Rock on.
Hook 'em horns.
Yeah, what is that movie? It's the Stallions, rock on. Let's see. K1 Manila, I'm sure we asked her about the recent interview. Someone had the team look for a pattern. That's what Jeff said they are actually doing right now. They're looking for a pattern.
But, like I said, to be honest with you, if you go by how the government frames it, it looks like they're doing their job, that they're doing it mostly first in, first out. So we're trying to figure that out.
Okay. And this same follow-up question, nobody from Milligan too. I don't have the list, but
that's not true. There have been some interviews that have gotten interviews.
Yes. All right. Do you think the judge will order preliminary intermediate scheduling of interviews to Go plan for fiscal year? I think he will actually do that. But I just don't know, when that might happen. Obviously, we're last year we're coming on the anniversary of the Gomez decision, which I believe was September 4th of 2020. So we're rapidly approaching that anniversary date. I hope we're not waiting for that same thing this year, but we could be. It's why we refuse to give you a date. And by the way, we're still looking for a date for the Go decision. If you've got a date, and let's see. Okay, K1 Moscow. What are the chances of getting visas this year? When you say this year, do you mean before September 30th or an actual normal person year?
I think the K1s don't care about fiscal years.
Yeah, that's probably not. So I think you're going to get them this year. And again, this is one of the questions we ask the government. What do you do about Moscow? When these countries and consulates are closed, that's why the case is so important. Once we survive the motion to dismiss in the Puerto Rico case, I think at that point they're going to, judge is going to say, what are you going to do? Have a status conference. Where are people going? Because nobody's getting interviewed in Moscow. If there's any consular officers left, I'm going to tell you there's not more than a couple. And so the numbers of people that are going to interview are non-existent. And again, our clients should be trying, I know many of you tried, to get third country consulates to do your visa. Okay? Oh, let's see. Ooh. You guys, you jump ahead and all of a sudden it jumps ahead. Okay. London case, we've just been told our case will be transferred. Woo, that's a good sign. If they are transferring your case, what do you guys guess? 30 days, 45 days?
I don't know, Elliot. I would actually reach out. There's a London Facebook page, and I would reach out to the other London plaintiffs to see, because they probably have a better idea at the specific consulate how long it's taking.
And or we can ask Lily, but Lily's not here tonight.
Yeah.
Lily, I'm sure would know. Let's see. Is there a possibility to bring a lawsuit for EAD delays for the AOS-based cases?
Under consideration. We're looking at the EAD issue broadly, and more to come on that issue.
Yeah, so we'll follow the page, and we will be updating you maybe as early as next week. USCIS versus Chakrabarty. It is assumed in the PI that I-40 is approved. What happens to be done if improved? Objective is current. Well, I mean, if you're not yet approved, the issue is once they get to your adjustment, they're going to adjudicate the I-140. All right. So the reality is, if they invited you to file the adjustment and the I-140 together, they have a legal obligation to do both in a reasonable period of time. Period. End of story. Right. So for us, it doesn't matter. Why did we use an I-140 approval? Because that's the best case, right? I mean, guys approve. What are you doing? You're costing him his status. But it's the same issue for both. I don't think the government's going to make any distinction, by the way, in their response to the preliminary injunction.
I don't either. The other thing that I would say is that save those rejections of premium processing, the notices where you've been rejected, because ultimately that may become an issue in the case too. If the government is saying, well, we can't do these cases because there's no adjustment available, there's no visa available because the I-140 is not approved. We want to be able to show them that you've tried to get it approved. You've tried to get it through premium process, and that's been.
So we may need that for the reply. Mm-hmm. In the AOS delay case, do you find any pattern in green card approvals? That's a good question. We have had people approved who did not have age-out kids. We just personally, in our firm, random approval. Just some dude we filed at the end of October, not even the beginning of October, approved. Let's
talk here about something that I'd like to believe that this is, partially because of our lawsuit. I think it's also because the government's panicking, but what was it, 2 weeks ago now, they announced that medical exams are now going to be valid for 4 years instead of 2 years. And, in our case, at our firm, we never submitted medical exams with employment-based adjustments because we knew that they would expire by the time the case got adjudicated or approved. And so we wait for the RFE to submit the medical exam. We're starting to get a ton of RFEs for medical exams for our cases. But more importantly, the government said, go ahead and submit your medical exam now. And they said not to wait for an RFE, right? So they're actually encouraging people to submit your medical exams. I don't know how, having done this for 23 years, that they're going to marry up those two documents, that they're going to marry up a medical exam to an adjudicator's file. I'm very concerned about that. So Greg's advice that I think is really good is get 2 different copies of the medical exam, both originals, in 2 sealed envelopes. One, you do what USCIS says and hope, like a snowball chance in hell that it's going to get to the file. And the other one you hold for an RFE, because if you get an RFE, there's a barcode on it. And that barcode is how they track the file to the case.
Yeah, in my firm, there's been a healthy debate amongst the lawyers on this particular issue. And there is I had offered the counsel that when you submit in your file the medical exam, to include a barcode that you can generate yourself in the letter, and also tape it to the envelope with the medical exam to improve your chance that it will get route to the right place. But I think, Jeff, you're right that there is a significant chance that it's not going to end up with the file. So you should not assume that that is going to work.
Can you imagine? You're in the mail room at the service center, and literally thousands of envelopes this big are coming in with just a case number on it. I mean, just really, it's
all right. But even that, it's how hard is it just to type the case number in the computer and be able to figure out where to route it? I mean, it's not that hard for them if they to get it to the right place.
If you were running the agency, Greg, I would have zero concern that was going to happen.
Yeah.
But you're not running the agency. It is, and there is a program. Isn't there an app that can generate a barcode?
Yeah, no, that's easy. That you could just Google that. There's a million of them.
So,
But how do you generate the right barcode to get it to the file?
I think you scan the barcode on the receipt.
On the receipt notice.
Yeah, and that generates the barcode.
No. You can generate a barcode just by typing in the text that you want to be embedded in the barcode. Barcodes are not, they're standardized. So you can get a barcode generator.
What's in the USCIS barcode? I don't know.
So what do you put in? The CIS receipt number and the A number?
Without the dashes, I'm told.
Okay.
It's there without the dashes. Oh, great. No dashes. Get 13 digits of numbers in the correct order without screwing that up.
And that's all that's embedded in that barcode. Any barcode reader can read anything that's generated by a barcode generator that has that code and that number in there. They'll scan it, and it's going to show the case number, and that's it.
So we have just given you the ultimate USCIS hack.
Yeah. So what do you mean? So okay, you identify the file. Where's the file? Oh, Bob's got it. Where's Bob? Oh, he's in the.
It's also not a bad idea to do that in general when you're interfiling anything, to generate a barcode to make it a little easier for them.
Yeah.
Jack had a question. And the answer to your question is yes, you are correct. In our opinion, will the USCIS oppose this PI?
Yes.
Yes.
Yes, we've already conferred with the government, and they are opposing it. They also asked for a continuance. Their reply is due on the 3rd. And although I hate doing this and I never do this, I said no in this case. I said, the deadline is the 30th. And I feel really bad that this very nice U.S. attorney is going on vacation that week, but we oppose the continuance.
I felt bad, but you did the right thing. I mean, I almost always say, okay, I mean, because this is a long-lasting relationship.
Yeah, she wanted 6 days. That's a full week.
Yeah, we can't wait. So
10% left.
Jeff took one for the team. Frank,
yes, but her reply, in the absence of a continuance, her reply is due on the 3rd of September.
And then we'll put our reply right back in after that. So are there any appetite for you all or AILA or Innovation to appeal the order? I don't know. We haven't talked yet to government counsel about this. Really, it would have to be Gomez that appealed that. And, they didn't ask for it. We asked for it, right? In the Aker case, we asked for it. So we need to talk to them to see what strategically is the better option moving forward. Let's see. The other thing, Greg, Jeff, you failed to mention was that right when we told the USCIS we were going to file this, they began adjudicating EBAOS cases, like a Banshee. And they said, we're going to prioritize these and naturalizations. That's what they said. Now, what they said that really interesting too, is they said most of these cases are at a service center. And that's not true. Only just over a half of these cases are at service centers. Just under a half are individual offices around the United States. So, and we've had reports of lawyers going to these EB interviews, and the officer says, "Why am I even interviewing you?"
Right, and I think we're going to see them waiving interviews sort of across the board. I bet that will happen.
Although we had this week, I think it was for like a physician that had to be about the cleanest case you can imagine, no issues at all, gets scheduled for an interview for an Indian physician for an adjustment, and by a local office, and it's like, well, they're clearly still doing it for cases where there's nothing at issue in the case, and I don't know why. And I've heard other lawyers saying the same thing. It is not uniform, the waivers right now.
No. And why is not Shadu making this go away? Isn't that why she's there? Why doesn't she say, we're going to change this stupid policy? Randomly do interviews like we always did, and you'll be fine.
We have some significant friends in the White House too, that know this issue. And I'm surprised that that they're still litigating this issue. To be
Well,
honest.
I got to tell you, the same thing happened in the Obama administration. They just keep going. And this is a good question. Now, I haven't delved into the numbers, Kamlesh. And when you say 40 versus 70, are you referring to the fact that they've reached 70% of the yearly capacity numbers for family, but only 40% for business? If that's what you're saying, we'll put that in the reply brief. That's a great factoid. They're just not even proportionally doing these visas. That's a great factoid for us. Let's see. Hey, Patrick, thank you very much. I appreciate that. A little pat on the back. Good for us. Chakrabarti, for Afghan SIVs, they agree. Oh, yeah, we talked about this earlier about the medical stuff. It would require a massive, because SIVs are under Department of State jurisdiction, and they have specific provisions in the FAM about this that are not in the regulations or policy. So new policy got to be approved by God knows who. That's not going to happen. Okay. One of the things that we're asking for is in this case is that they allocate the visa number upon filing of the adjustment. I mean, that right there, if they did that and they didn't wait for the approval, that solves the problem. I mean, there's no more problem at that point.
Which is our argument in the H-1B context, right? So, very similar statutory language. In fact, I think the AOS case is stronger because there's clearly a floor in the AOS case. There's not a floor in the H-1B case. There's only a cap. But for counting purposes, USCIS is fine with that number being reserved at the time the petition is filed, even though it's ultimately not counted until the visa is issued. So I don't know why they have to treat them differently.
Cy makes a good question. Jeff, why don't you ask the government why they've approved 50,000 family-based 74? Well, first of all, we don't get to question the government lawyer. That's not how it works. But what we do is we bring this up in our pleadings, in our briefs, and our argument. Judge, how is it conceivable that the Department of State has approved 70% of the family-based cases that are available this year, and yet that makes no sense? And that's why equity requires you to reserve these visas.
I think we have to look at the data, because family-based also includes immediate, and they may be doubling up immediate relatives with preference. So we just have to look at the numbers.
Let's see. Can a plaintiff who is now in the United States on a tourist visa adjust status if Judge Maida reserves visas? That's a really good question. My answer would be no. That would be my answer, because we've only sued the Department of State. We have not sued USCIS. And so I think you have to consider a process.
Or adjust, or give it up and adjust if you think that that's going to be faster and you have a better chance. But
I just don't know if you can adjust if we reserve the visa. I just don't know whether that's a legal option. That's an answer we'll have to get you later.
Yep.
Let's see. Let's see here. Chakrabarti, I have two cases. One is an approved I-140, his wife. Another has I-140 pending getting grade for you. If the U.S. picks my later case, do they know what A number that I have? Well, here's the thing. You would think that a computer would say, hey, Viv the gamer has 2 cases pending. Alert, cancel one of them because he has a green card. You would think that. But we can't confirm that's true. We don't know. Just like this is actually the hugest complaint that Charlie Oppenheim has when he does the visas. Does the USCIS tell Charlie Oppenheim not how many EB2s and EB2s are pending, but also how many duplicate EB2s and EB3 downgrades there are? So that's why we believe there's not a backlog that they say there is, because they're not distinguishing the duplicate applications. Yes, it's frustrating. Something by the way, we've asked for this for years, and nothing. And if you are aware of the 2007 visa debacle with the visa bulletin, that was one of the reasons that happened. Charlie will never do that again. Maybe his last month when he's working, maybe he'll do that then. Let's see. Do I think this is a really good question? Do you think the Afghan issue will cause a further slowdown in processing in Texas? No. But
with USCIS, although the Dallas lockbox is where the humanitarian parole applications are being adjudicated. I don't know how many of those are going to go in. I know I'm working on several, but I can't imagine that that's going to have that significant of an impact in tech.
I don't.
I think it's being run by a completely different division of USCIS.
Yeah.
So
I don't see that. But the better question is, will the Afghan debacle affect consular visa processing around the world? And the answer is yes.
Yes.
Yeah, we already know that's happening.
We know that because they just told us today they're sending officers from Ciudad Juarez to Afghanistan, which means they're not going to be doing the cases in Ciudad Juarez. And I'm sure they're not the only ones. Plus, keep in mind, virtually all the non-U.S. citizen permanent residents that they've flown out of Afghanistan have not come to the United States. Most of them have gone to third countries, which means the consular services in those countries will be adjudicating the SIV cases. So, yes, this will cause a massive backlog in a lot of different countries that already have massive backlogs. And by the way, completely preventable. Let's see. By the way, has Secretary Blinken resigned yet? I'm just asking for a friend. Just asking. It's funny. Nobody's blaming him. It's like State Department is completely blameless in this. I mean, they are the bottleneck. They are the place that's causing a lot of these issues. So, let's see. Oh, this is not really part of our litigation, but I will answer this because I think it's a good question. What is the situation of the injunction against ICE, prosecutor discretion, and immigration court after today's state order? Jeff, do you want to take that?
Yeah, that was good news today.
Yeah, so Judge Tipton, the same judge that issued the injunction, issued a stay of the injunction until August 30th. So 1 week stay of the injunction, basically because it seems like the government is not, his position is that the government's not properly interpreting his order. And so, so stay tuned for what will happen. It doesn't mean that the injunction is going to go away. I think, he very well could narrow the scope of the injunction to make it more clear about what he's talking about, that whether it really is just detention that he's talking about or not. And we should know next week about what that'll look like.
My favorite thing about his order was that, hey, I don't want a report. I mean, I don't want that. I want this. And here's what really frustrated me, Jeff, is that literally within 48 hours of his order, ICE had ordered every one of their prosecutors to no longer exercise discretion within 48 hours.
Yeah.
Do you think they're going to do that now?
It's as if they wanted to be told that they didn't have to do it.
So if it stayed, will they now undo their order within 48 hours? No, they won't. This is what's extraordinarily frustrating again about the Biden administration. What they should do is say, you know what, we're going to do them again. Everybody's granted. Boom, poof, gone. And that when it comes back, oh yeah, we got nothing left. We got nothing here. Thank you very much. That's what I think they should do. Somebody asked a really good question about those denied in the Muslim ban. And as I said earlier, that is one of the questions that I asked the Department of State and that they have refused to answer. So that question will come to the judge's attention. And maybe he makes them answer it, maybe he doesn't. But obviously, if the only reason you were denied a DD 2020 is the Muslim ban, I think it should be issued a visa. I do. I mean, I think that's the only fair thing to do. Let's see what we got here. Let's see. Sorry about the echo. I don't know why we have an echo. It's not on my end, though. I don't think I have it.
It got a little better. Might have been Aaron.
It might have been. Let's see. Let's see. A lot of these questions are already answered here. There's a bill floating around Congress which would take away the FBEB spillover.
Mang Amendment. Yeah, I am doubtful that that's going to go anywhere for the same reason it didn't go anywhere last year. First of all, there's a practical problem with it, which is they use the exact same language as when it was written, which was before the rollover on September 30th of last year, October 1st. So it acts like you can just stop and just push all the numbers back in. It doesn't account for the fact that a lot of people have actually gotten adjudicated. So the way this reads, it's as it would seem to be that you would have to revoke green cards and from people that have already gotten approved, which I am fairly certain that is not what was intended, and they will have to make a change to that if it's going to go anywhere. But I don't think it's going to go anywhere. So I wouldn't worry too much about that. I think that that this is sort of just to raise this issue that family-based lost these numbers. Hopefully what's going to happen is we're going to get some immigration reform and that the numbers are going to go up across the board. So it's going to be current for everybody and it won't matter. But I wouldn't lose too much sleep over the Maine Amendment at this point. I don't think it has very much of a chance.
The other thing that nobody really talks about much is in the family-based categories. If there is some sort of legalization plan, demand's going to go way down because there's a lot of people in the family-based lines that are here in the United States.
And the employment-based lines too. I mean, there's people that may be able to regularize through that employment.
Yeah, that's true. And also there won't be as much of a panic because essential workers, I think, have about a 90% overlap with the H-1B population, the way that's written. And I think that a lot of people are going to be lawful provisional immigrants and will have they'll know they'll be able to get a green card in 5 years through that program if it happens. So that will change a lot of things.
All right. So Jeff, I know this is, that's not the one I wanted to let's see. Who guaranteed there to be no COVID and no disease? Yeah, well, I agree. There's one I wanted to, this one right here, Jeff. Judge Boasberg, this is a mandamus, would help out the Ramirez case.
100%. In fact, if we get a good decision out of Judge Boasberg, we will immediately file that as persuasive authority in the Ramirez case, as the fact that another judge has found that the delay is unreasonable. So 100%.
All right. Well, next to last question is, what will happen to DV 2022? All right. Here's our advice. This is really simple advice. If you won DV 2022, go online right now and fill out your DS 260. And as soon as that's done, send your documents in. That's what you need to do. Don't wait to be told to send your documents in. Ignore the letter you'll get back. Says, we'll let you know when to send documents in. The lesson we have learned, send all your documents in. Now, don't wait. All right? That's what I would do.
And we're going to end up filing a suit in DV20. You see no change in the behavior of the government at this point after these two, DV 2020 and DV 2021 litigation. So expect that to happen probably around the same time we filed for last year.
Typically, the Department of State would be giving interviews 45 days out, 60 days out. As far as we know, there's no DB 2022 visa scheduled for appointment in October. None. So, take that for what it's worth. Let's see. Some people are nervous about learning that Judge Maida refused to give priority to Vincent Gomez, and are afraid he would do the same. We're concerned about that too, but we remain confident. Again, we have a very different case in the Gomez case. We don't have a class action. We represent you. And that's going to be our job to focus and get you approved. All right, everybody. Great questions today. We appreciate you. We will see you next Monday together on our Impact channel. Tomorrow, Jeff, you're on board. Greg, you're on board tomorrow, right?
1 p.m. Central.
Jeff and I on Wednesday.
I'm on Thursday, actually. I'm on Thursday at noon.
Thursday now. All right.
Thursday at 2 o'clock Eastern time.
And I'll be Wednesday at 2 o'clock. You get to see all our smiling faces this week. That'd be awesome. All right, guys. Have a great week. Bye-bye.
Bye-bye, everybody.